Hey guys, and welcome to the weekly docket. In Wisconsin, Darrell Brooks has a restitution hearing coming up next week. Typically, a restitution hearing would involve evidence on allowable losses by victims, any argument over that by the defense, the defendant's ability to pay, and that sort of thing. Restitution is probably a dry hole here, as Brooks is certainly broke, and any wages he makes in jail and money sent to him are subject to a max of 50% going to restitution. 50% of nothing or almost nothing is still nothing, or even slightly less than almost nothing. Anyway, I've got a video coming out tomorrow that goes over the total situation in greater detail, including civil claims, how to do that, what it could happen, how Son of Sam laws aren't what people think they are, and the Wisconsin Crime Victim Compensation Fund that does help victims cover costs. In Indiana, Richard Allen's attorneys have made an emergency motion to have him transferred from the prison he's in right now. They say he's shunted off to a maximum security facility quite a distance away, and what is happening to him there is prejudicing his ability to mount a defense. They put out a picture of him to show the physical changes he's undergone, that prison diet. Some people seem to gain a lot of weight. Looks like he's losing it. Yeah, he's lost a lot of weight, but that by itself doesn't mean where he is the wrong place to hold him. Let's see what they say about this place. He's been entombed in a cell as small as 6 feet in width by 10 feet, a space no larger than that of a dog kennel. Entombed. He's sleeping on a pad on a concrete floor. He's afforded showers only 1 to 2 times a week. He's required to wear the same clothes, days and days on end. It's all soiled, stained, tattered, and torn. Sounds kind of like a Kid Rock song. He's constitutionally innocent, yes. And he maintains his factual innocence, yes. And he hasn't been able to visit his wife or his other family members during the last 5 months. With conditions like a prisoner of war. I guess it depends on which war you're in. Mr. Allen is allowed only an electronic tablet through which he can make calls to family members. And you know it's no sweet iPad. It's some knockoff brand. It's monitored by the prison. The cost of all phone calls are borne by him and his family, and sometimes the cost they get charged is pretty extortionate, and I'm not soft on crime. Anyway, he is routinely supervised by other inmates, companions, as they're referred to within the confines of a prison. That sounds nice, a companion. They sit outside and watch his cell door on a daily basis. I guess they're not letting him out. He gets very little, if any, recreation outside of his cold concrete and metal quarters. It was a dark and stormy night. They've delivered nearly 1,000 pages of police reports to him. And he's very isolated and that sort of thing. So it sounds very bad, of course. You have to sort past the attempts to be Ernest Hemingway in the descriptions and get to what's really going on. That said, they say they have a spot at a secure jail. It's closer to the case, and that the prosecutor has no objection to this transfer. And in that situation, he would be allowed family visits and be able to coordinate with his defense team more easily and more effectively. Now, I've seen a lot of people saying, hey, he's getting what he deserves where he's at. And I realize they may be exaggerating it. I don't know. But isn't the idea of him getting what he deserves that he at least has the trial first? His confinement at this point is due to the nature of the charges and the assumed need to protect the public, not because he's been found guilty. This isn't supposed to be punishment yet, people. So I'd say if there is a closer facility that works, he should be moved unless it can be shown it just wouldn't be safe. Now, defense plays another card, which is if you don't like the fact that he's being treated so bad, you don't have sympathy for that. He's losing his cognitive ability. They say the ability to communicate, to remember, to reason, and to assist with his defense, those things are being materially diminished. Now, this could set up a competency to stand trial evaluation, which could slow the whole thing down. So while it might be true, it also is probably leverage for the defense to say, look, get this guy out of here and let him be somewhere more reasonable, and we don't have to worry about competency in this trial. But if you keep him where he's at, we're going to make an issue out of it. There's a lot of nonsense surrounding this case. I don't like criminals. I don't like murderers. I support the death penalty. Having said all that, before the trial, the person should, if they're going to be confined, that should happen in a way in which they can support their defense. It really shouldn't be designed toward punishment, but more toward safety. So while I'm, often not sympathetic to the defense, I hear what they're saying here. And I would be surprised if the judge doesn't make some kind of ruling on this unless law enforcement can say this just wouldn't be safe, because even the DA doesn't contest this. The DA that wants the guy in prison doesn't contest this. In Idaho, Vallow jury selection continues, and I think they're supposed to get to opening arguments potentially Monday. The parties inch closer to opening this trial. She continued her vile arguments to keep relatives of the children who actually cared about them out of the trial as much as possible. Using the witness exclusion rule, it can be used to exclude witnesses who are going to testify from sitting in court and hearing testimony before they take the stand. Vallow, of course, allegedly had her husband killed, and so that removes the father. He can't sit there for these kids because he's been murdered. Her brother killed himself, I think, and you have to think that's due to his involvement in her criminal actions. Well, JJ can't show up for his sister Tylee because Vallow had him murdered, and Tylee can't show up for JJ because Vallow had her murdered. How many people does a gal got to kill to keep the courtroom free of these pesky victim sympathizers? The judge did finally, however, settle this matter. He noted the court had not received the forms Idaho uses for a person who wants to assert rights as a victim, despite the court previously having said, hey, I need these forms. I'm not sure why the state and the grandparents and the aunt, if she didn't turn it in either, why they didn't get those forms turned in. Anyway, the judge does not find the grandparents or Vallow's sister are victims or immediate family members, that kind say who can speak at sentencing hearings, because that definition doesn't include grandparents or aunts. But the court does note that since JJ's legal father, Charles, was murdered, he's deceased is all the court really found there, the court can appoint a representative from the immediate family to serve in the father's stead. And the court found it, quote, wholly appropriate, end quote, to designate Kay, the grandmother/aunt, to do this for JJ. The court notes regarding Tylee that her father is deceased and her mother is not available to fulfill the role. So the court appoints the aunt, her sister, Summer Shiflett, who wanted to come, and says, hey, she can stay in the courtroom with Kay during this testimony. Only Larry, the designated grandfather, lost on this one. But the court said, look, hey, I'm going to exclude him, but if you call him first in the trial or early in the trial, he can sit there the rest of the time after that. So there's a solution here. It's a pretty balanced ruling overall, in my impression. Well, that's it for this week. Thanks. Bye.